So you may have property, perhaps it's a house, a piece of land, but that's all you have. You have nothing to prove or nothing to state ownership, or if you die, what happens to your property? These are some questions that we're often left wondering. So to clarify that and more, joining me on set this morning, I've got the paralegal, Mr. Michael Lopez. Good morning to you, Mr. Lopez.
Good morning, Christy. Nice to meet you.
How are you this morning?
I'm doing just fine. Thank you. Thank you for having me.
Yes, and now we're off to a little later start than expected, but nonetheless, we're grateful here this morning.
I understand.
Before we get into today's show, just tell us a bit about who exactly is Michael Lopez.
I am a paralegal by profession.
Yeah.
Learning the trade or learning the profession was a bit unorthodox for me.
Yeah.
Because I was thrown into the area of law and thrown into the area of being a paralegal.
Yeah.
Because the company that I worked for previously had their financial issues as a result of the crash of Clico Investment Bank.
Yes.
As a result of that, they couldn't afford to pay their lawyers, and all of their lawyers naturally left. A lot of litigation was sitting around just moving forward without attorneys at the helm. So at the time I was in law school, I was still in my first year, and I picked up the law cases and asked my CEO and my chairman, listen, would you mind if I took a stab at this? Because I mean, I do understand a bit about the law already. It would be an opportunity for me, and it would help you all to at least keep your law cases alive. Otherwise, you're going to lose all of them by default. As a result, I learned a great deal about law. I learned a great deal about the rules of court and the proceedings. So, after following through on some of the cases, and I won 2 cases actually.
Wow.
I just took it from there. I decided to specialize in the area of estate planning and succession planning because it allows me to help people.
Yeah, and I think we have very few persons who have actually studied that.
There are quite a few attorneys who actually practice estate planning. There are law firms that they specialize in estate planning, and they're available. The difference between the law firms and the paralegal is what we do. We are actually not sitting in our offices waiting for persons to come in, because by the time they come in, they have a big problem. They may have been trying to resolve their problems on their own. They may not have realized that the problem was snowballing all along. So by the time they get to an attorney who specializes in estate planning, their situation is probably very dark and they're looking to resolve it. I know for a fact that just the conference room conversations with persons who are trying to resolve their land issues and their estate issues is usually a conversation where we have to first bring in a glass of water before we start and a box of napkins, because there is going to be crying and weeping and accusing, and people are usually in disbelief that their family is now so split apart because someone in their family history failed to do any estate planning.
And it's like you rightly said, it has the tendency to split families.
Yes, it
like
does.
sometimes you think it's there, but sometimes these things just kind of amplify it, and you see how much of a big problem it really is, especially when it comes down to property I mean,
There's something
you
about
see it.
property.
You see it
You know,
all the time.
a lot of the mistakes that parents make is that they look at their children, they know how they raised their children, and these are their words, almost literally. Listen, I didn't raise y'all to fight with each other, all right? I didn't raise y'all that way. And the parent is probably right, all right? You all don't fight. So the piece in the front, I'm leaving for you.
Yeah.
The piece in the back, I'm leaving for your sister. And your little brother, he's small right now. You all make sure he has a roof over his head, or he always has something. Yeah? Don't leave him out. And usually, the promises made in those conversations are sincere.
Yeah.
Except when someone dies in a family,
Everything dies. It promises everything.
those things go out the window, and it's not usually because people are malicious, or because they were insincere when they made the promises. Here's what usually happens. You made the promise to mom and dad that don't worry, we are not going to fight. Yes, you said that the piece in the front is for me. You said the piece in the back is for my sister, and make sure to take care of our little brother. And they are doing that.
Of course.
Except when mommy dies with the property still in her name, or when daddy dies, or granddad dies, or grandmother dies with the property still in her name, usually the process for transferring that property from their name to the beneficiaries or the inheritors is one that nobody really considered. In the meantime, the children are getting married. The children are getting into relationships.
And now you have the outside
now you have an outside influence determining what happens.
to do with this property.
Because all of a sudden, my wife or your husband is trying to encourage you to take it all. Or
You see the house
they
there?
don't. You see that house?
That's up a business,
Exactly. Or my wife might be saying to me, I don't trust her, I never trusted her. And while she's telling me that, I am forming opinions in my mind about the very sister or the very brother that I grew up with. And those things fester, and animosity is created and developed, and before you know it, families are being split apart without them even realizing that it was happening.
And that's why we need a will.
That's why you need a will, or you need some sort of succession planning.
Yes. I shouldn't just say a will, something to, in the event of death especially, because this is where the issue comes in more often than not. So before we go further into the importance of a will, first of all, what exactly is a will?
A will is a document containing written instructions as to what you want to happen with your property and your estate after you die. There are legal components to a will that make it binding, and if those things are not there, then that is not a will. It's just a piece of paper that you wrote some instructions on. But if it does not follow all of the perimeters or the guidelines that make it a binding instrument, then it will not succeed.
No pun intended.
No pun intended.
I mean, I'm sure many people may not know the importance of having a will, or like you were just saying, succession planning.
Yes.
Just briefly explain to us, what is the importance of it?
Well, I always say that the tragedy of death in any family is real.
Yeah.
But if after we mourn for our loved ones,
and reality sets back
and
in.
reality sets in, if that loved one died owning property without first leaving instructions to how it is to be treated with after they die, then that family usually realizes the real tragedy of that person's death. They're going to have legal issues. For instance, if it is, let's say, tea and TNTech has a mandate, TNTech has a policy that if someone dies and that person was one of their clients, meaning that the TNTech account is in that person's name, the obligation rests on the family to report the death of that person to TNTech. So TNTech does not like to continue supplying electricity and writing its bills to a person who is now deceased. But people allow it to continue until one day when they have a TNTech problem and TNTech suddenly discovers, because they have no other choice but to admit to TNTech that this person died 5 years ago or 10 years or 17 years ago. And now look at where we are. If you have to upgrade your home, if you have to do any kind of rewiring and inspection is required, they're going to discover that this person is not alive.
And I'm guessing that's where the importance of even channeling information like that is important.
Absolutely. So if someone dies without any succession planning, it's important for the rest of the family to know what to do. And there are many different options which we discuss at our lectures, and when persons come into our offices, we explain to them how they can correct the problem that exists, because all is not lost. If someone failed to do any sort of succession planning and the family finds itself in these dire straits, all is not lost. A qualified attorney or even a paralegal like myself who is actually practicing or following or pursuing those disciplines can help you. The paralegal does not practice law, we cannot by law, but we can guide you and teach you the strategies that you will need to go forward.
Now, in some instances when, let's say you have a well-kept family, everything is nice, you know, as well as could be. But in the event one party dies, let's say the mother dies and the property belonged to her, what are some of the tragedies now the family can face because there was no sort of succession planning, no will, nothing, so you just everything is there?
I'll explain some of the tragedies that I have encountered. Take for instance the rest
I imagine you would encounter a lot.
I encounter a lot.
Because I do think the importance of a will has kind of stuck in the minds of ours. And I must commend you on that. I mean, you've been doing your part. You continue to do it here. So, yeah.
Some of the tragedies, take for instance, I know of one elderly gentleman who he didn't prepare a will, but he did a deed of gift.
Okay.
He did a deed of gift, which is a form of succession planning. He did do a deed of gift to his daughter and his son-in-law. And everything was hunky-dory until the daughter and the son-in-law got divorced in a very bitter, ugly divorce, like some divorces, like what happens in some divorces. As a result, as the voice of reason in the family network, the father-in-law decided he would side with his son-in-law. He believed that the son-in-law was acting reasonably and that his own daughter was the one who was acting unreasonably. So he thought he would tell her, listen, I think you should really reconsider what you're doing. She fell out with her father, and as a result, when the divorce was final and the property was being split up or settled,
the deed of gift was given.
The deed of gift, the ownership of the property was given to the daughter. And she threw him out.
Wow.
He was 81 years old. The property had belonged to him originally. He only gave it to them so that they can get a loan to do some renovations to the property as a whole. But when he passed it on to them, he passed it on to them for their absolute use and benefit. He held no title or no interest in the property that he was still living on. So when the family unit broke down as a result of the younger couple's divorce,
Yeah.
she threw him out and sold the property. He later, months later, committed suicide.
Oh my God.
These are some of the,
Yeah.
that's just one of the
And even
ugly
with that,
stories.
now you see, you need to have some sort of advice before you even
Definitely,
do
before
something like that.
you embark on
Save
any
yourself.
succession planning,
Yeah.
get some
I mean,
advice.
the way things are right now too, you want to protect yourself. You don't want to end up homeless.
Get some. He was homeless when
Yeah.
his daughter sold the property, kept the money, and put him out of his own home. So you
Yeah.
have situations like that happening. Then you have situations where family members secretly take the patriarch of the family,
Yeah.
who might be the person in whose name the property is listed, and they might secretly take them to a lawyer and get the property transferred, or let them do some
Yeah.
sort of
And
thing.
you know, because you're talking about that, it just brings me up to another point where, you know, sometimes you're old, you're not really thinking, okay, well, is my child going to outsmart
Yes,
me?
it happens.
No, I raised this child better.
It happens.
And you just, you know, you raise your lovely daughter and she comes, okay, daddy, sign this.
Yes.
And we have a big problem. We sign anything without reading.
Yes, because we trust. A lot of us trust. And what people we trust a lot are our lawyers as well. We trust our attorneys because they're our representatives,
Yeah.
legal representatives. But if it is that you didn't understand what the attorney was explaining, then ask him to explain it again. Tell him, listen, I don't understand the
Yeah.
legal language that you're using.
Yeah, break it down for me.
Break it down for me so that I can understand. Ask questions. Okay, what are the downfalls of what I'm about to do? What are the pros and what are the cons? If I need to protect myself, how should I protect myself from doing this? Now, those are transactions that you can do while you are still alive.
Yeah.
Things like deeds of gift, things like actually selling the property to another person, things like even exchanging property between one person and another. But that brings me to the next option, a will.
Yeah.
A will is actually an instruction, a written instruction following certain guidelines that you will leave for persons to know how to treat with your estate after you die. So it is not active at all while you are still alive.
Yeah.
But the minute you die, it
Becomes
comes to
effective.
life. And you have left those instructions for someone else called the executor to follow your instructions to the letter. The executor is not allowed to interpret what they think you meant.
I'm sure you've come across cases where the executor thinks that, well, they're the owner of the property, so they set up shop.
Yes.
And they think, well, all right, they
Yes.
left this for me, not knowing. So now what is the difference between the executor and the actual owner, or the person who the property or the estate was, you know, left for?
Well, I want to start answering that question by explaining what the word estate means. Your estate is any property belonging to you at the time of your death. So it means that if you die owning real estate,
Yes.
that becomes part of your estate. If you die owning money in the bank, unit trust, deposits and shares at your credit union, shoes, clothing, intellectual property, all of that is included in the definition
Estate.
of your estate. Now, the responsibility of the executor is to distribute your estate as you indicated in your will. He's also responsible for clearing up any enforceable debts that you still had at the time of your death. And when I say enforceable, that word, I'm very careful to insert that word, because some of your debts are not enforceable, meaning that you may have had something put in place to take care of that. You may have taken out a loan and the loan had a built-in insurance policy
Yeah.
with the idea that if you die, that insurance
insurance
policy
would
is supposed to cover that.
Yeah.
Or you may have a loan that is unsecured that has to be taken care of by liquidating your assets and taking care of that. So there's a difference between enforceable and unenforceable.
Okay.
The executor should be only responsible for taking care of your enforceable debts, because you would be surprised the amount of people who turn up after you die indicating that you owed me money or you owed me this, or you had signed something, an agreement with me years ago, and I'm here to claim
I'd imagine the myriad of problems
my
that comes
share.
with it.
So the executor's job is to understand the letter of the document
Yes.
and literally interpret it. He is not supposed to imagine what you may have meant. He is supposed to follow that.
Yeah.
And in a court of law, a will is enforceable. It will stand up as your last testament in a court of law, and it will be followed. So the executor, the trouble with some executors, because you have to select your executor carefully,
Yeah.
they may be the wrong person. You may have chosen the wrong
Before we go
person.
any further, does the executor have to be a family member, or can it be someone outside of your family? Or?
An executor can be anyone that you choose.
Okay.
It can be your attorney.
Okay.
It can be a friend. It can be a family member. They should be above the age of 18 so that they can be, they have an age of majority and they can be recognized in a court of law.
Okay. So
All right. But the executor that you choose, sometimes if you chose the wrong person, or maybe they didn't understand their job.
Yeah.
Sometimes an executor will be so busy enjoying the very property that they're supposed to be distributing for you that they never distribute it. Let's say it's a house.
Yeah.
They move into the house and act as though it's
They
their
are
own.
the owners.
Let's say it's a
Yeah.
car. They're so busy enjoying driving the car that they don't remember, I have to say
There is
remember,
a rightful owner.
that there is a beneficiary.
Yeah.
You left instructions in your will that your son is supposed to inherit the house, or your daughter or your niece is supposed to inherit the house, but your executor moved in
Yeah.
and he is acting as though he is the owner. So the beneficiaries, which is a fancy word for inheritors, have options. Once 6 months pass, they can take the executor to court.
Okay.
They can have him removed as executor by making an application to the court, and they can appoint one of their number to become the new executor and distribute the property according to the wishes of your will.
Very, very interesting there. And in case you're now joining us here on PSA TV, this is the Wake Up Call. We are chatting here with the paralegal, Mr. Michael Lopez. And I've had the opportunity to sit in one of his lectures where I learned so much, especially the importance of a will, because, you know, traditionally we aren't really taught much about properties and inheriting stuff.
Yes.
So I myself, a will, the importance of having a will, or just talking about succession planning and informing your parents as well, because
Yes.
sometimes that's where the problem lies, that your
Yes.
parents may not have done the proper thing. So
Yeah.
now you're stuck with, okay, how do I go about
Yes.
doing this? My mother died, my father died. How do I do this? My brother is on my back. No, that property is mine. So
Yes.
how do we go about doing the entire thing?
Well, one client of mine, whose name I will not call, her mother had already done a will, but the will was saddling her, the daughter. It was saddling the daughter with immense problems from her brother and sister and this one, because the mother had some really awkward situations in place, and she was allowing herself to be taken advantage of by her own children. Yet the will left the property to another daughter who she considered to be the responsible daughter. So the responsible daughter saw me and said, listen, after hearing your lecture, I'm looking at my mother's will that she is leaving for me, and I can tell that she's leaving me with all of these problems. So I would like you to talk to her.
Just clear it
and
up.
clear it up. So when I spoke with the mother, she said, well, I realize I am leaving my daughter with lots of problems. Could you revise this for me? We revised it. When she was happy, and the daughter was happy to accept the responsibility that the mother was leaving for her, then the mother executed a new will. Now, wills are not written in stone until you die.
So you can change, you can make your variations.
You
as
can
the case
change
may
a will as many times as you desire
Okay.
while you are still alive.
So if I were to put you as my beneficiary,
Yes.
and 2 years from now I decided, well, okay, I don't think I want to leave
Right.
you as beneficiary, I can change that.
You can change that, yes. As circumstances change, you can change it. People enter your family in two different ways: through marriage
And this,
and through birth.
right.
New people enter families every day. They're born into families, and people marry into families. If it is that you are doing a will, it needs to be updated every 3 or so years.
Okay.
Every 3 or so years, depending on your age. If you're an ageable person, every 2 or 3 years you should revise your will. If you're a younger person, then every 5 years or so you should revise your will. Take it out, have a look at it,
Yeah.
see what circumstances have changed, and make the changes accordingly. But it is not.
And also ensure
Written in
there are no
stone.
loopholes.
Ensure that there are no loopholes, because loopholes are created based on changes in circumstances. So that can be fixed. Change your will. The beneficiaries are usually either informed or not informed. You can keep your will as a confidential document that you choose not to share with too many people, or you can be very open about your will and say, hey, everybody, I did a will, you're in it, you're in it, you're in it, and you're in it. Or you can decide, hey, I'm only going to tell 1 or 2 people.
Yeah.
But telling no one is a bad
That
idea.
is, yeah.
Because if nobody knows about your will, or nobody knows that you even have a will,
Then in the event that you die, then
nobody's
nobody
going to
knows
go
anything.
looking for a will.
No.
If it is, however, that they are going to try to transfer your property from your estate,
Yes.
from your name as you are now deceased, to their own, once they start those proceedings, they will be forced by law to begin the proceedings by doing a search at the Hall of Justice in the probate section. And that will reveal, if you deposited your will there, that will reveal that yes, you did do a will and you did lodge it there,
Yeah.
and it is now on the table for everyone to consider. If, however, you did a will, you hid it under your pillow, you never told anybody about it, you never chose to deposit it at the Hall of Justice in the depository, and you did nothing of the sort, and no one ever finds it, then for all intents and purposes, you died without a will.
Yeah, yeah. We often hear this term, probate, and you just used it. So for the viewing audience who may not know the term, what does probate means?
I'm going to try to just use a synonym. I'm going to try to use the word process.
Right.
Probating a will, for persons who don't use the word probate, is the same as processing that
Right,
will.
it's just a fancy legal term.
It's a legal term, but I try to break it down as much as I possibly can. So to probate the will means to process the will.
Right.
And to do so, you must begin by doing a search at the same Hall of Justice in the probate section and confirming whether or not this person, the deceased, confirming whether or not they had any new wills lodged there. Because it's very easy for you, Christy, to do a will right now, leaving me as a beneficiary.
Yeah.
And then tomorrow, you do a new will, not leaving me as any beneficiary. Now, the will that's going to stand is the new one, because the name implies that this is my last will and testament.
Yeah.
So, if I do one tomorrow, that makes the one I did today null and void, obsolete. So, if I do one tomorrow and I lodge that one at the Hall of Justice, that's the one that will be recognized as my last will and testament. So it's very easy for you to just do a new one and lodge it there. Or do a new one and keep it somewhere in your vault at home or somewhere. But once the both wills surface, the one with the most recent date is your last will and testament. The one before that is invalid.
Right. So this is PSA TV. We've been chatting this morning with the paralegal, basically showing you and telling you the importance of a will of succession planning. We're going to toss to a really short break and come back with more. Stay with us. And welcome back to PSA TV. I am Christy Kali Singh. On set, I've got with me the paralegal, Mr. Michael Lopez, and we've been chatting about the importance of a will of succession planning and why you should have one. And I'm speaking to you as in you in general. Now, oftentimes we hear this myth that, you know,
Yes.
wills are for just the old people.
Yes.
You know.
We hear that a lot.
Yeah, and the average young person might be like,
Hello?
I don't need a will.
Excuse me.
Why do you need a will?
Yeah.
But how important is it for a young person? And first of all, should a young person get a will?
Well, what's important is to strategize your life. And it's a phobia, it's a myth that circulates throughout society that wills are for old people. People who are getting ready to die, people who are in a wheelchair, or people who have gray hair, and that kind of business. But it's not true. It's not true at all. From the minute you hit 18 years old, you are eligible by law to prepare a will.
Okay.
And I do have one instance of a 20-year-old who should have prepared a will. He died without preparing it, and his father is presently in a very difficult situation with respect to the son's estate because he didn't prepare a will. And a lot of young people will be saying, and they're probably asking now by viewing this broadcast, that, excuse me, but I don't have any assets as yet. I don't own any property. All I have is a little job, and my money is to buy sneakers and to go to a party and to buy outfits and stuff like that. My parents are the ones with assets. But some of the times, your parents are relying on you to take charge of certain situations. In this particular instance, this parent, at the time of his son's birth, he set up a credit union account.
Yeah.
And in fact, he set up two. One for himself and one for his baby boy. He allowed himself to be the beneficiary on his son's account and his son to be the beneficiary on his account. And they grew up together, and the father was being the employed person, had a standing order, and he was sending money into those two credit union accounts for 20 years, every month, religiously. Now,
that's a lot of money.
That's a lot of money. It's going to accumulate. Eventually, at age 20, unexpectedly the son dies.
Yeah.
So what does the father do? He decides he's going to, at some point, withdraw the money from the son's account.
Yeah.
What he did not know is that the laws of Trinidad and Tobago only allows the beneficiary on a credit union account to withdraw up to $5,000. The rest of the money, any balance, any difference, is stuck right there in that credit union account unless you get an attorney to file an application for letters of administration.
Yes.
So that's where the father is right now. He is trying to file an application for letters of administration so that he can get the money out of his son's account. The trouble he is having is that the court's formula for distributing the estate of a deceased person if they die without a will requires that the money be shared up among family members. Now suppose the father did not want his money that he put into the son's account shared up with any family members because the money belongs to him.
Yeah.
And there are family members who are sitting there waiting for their share of his money, but he's between a rock and a hard place. Had he prepared a will instead of doing it like that, now that's all well and good. That's a good idea for succession planning and estate planning, but it is not complete because the law has put a ceiling on the amount of money that the beneficiary can actually get. So what happens to the difference? We need to put something in place. My recommendation is always put a will in place. The will take care of the full amount and not just $5,000. There are things like unit trust investments. With unit trust investments, unit trust has their policy, which allows beneficiaries to come and withdraw 100% of the money that's in the unit trust account. So if someone is doing estate planning, unit trust accounts are a good option. If you have investments on the stock market in Trinidad and Tobago, you have bonds or you have purchased shares in companies, etc. There are many different options that you have inside of there because different investments allow you to act differently. Some of them you can put in your will, others you can make the brokerage account joint with a family member or the beneficiary, and that person has access to it. The trouble with some of them is if you make your account joint, that person can actually...
Yeah, I was just going to ask you about that. In the case where there is a joint account, how would a will work?
In the case of a joint account, the person who the account is joint with always has the option of coming behind your back and withdrawing your investment. So, you should get advice. Get advice from a qualified attorney who specializes in the field of estate planning. Get advice from a paralegal like myself who specializes in the area of estate planning. And I wouldn't even give you advice because I'm not authorized to give advice, but I will guide you as to how you should strategize on your own as to how you would like to do things. Things like bank accounts, you should get some advice. Things like other investments like real estate, get some advice because if you have in your deed that the property is held jointly with another person or other persons, you've got to know that there are different forms or different ways that property can be held jointly with other persons. It's joint doesn't just mean joint. Joint occurs in two different ways. There's joint tenancy and there's tenancy in common. Joint tenancy means if you and I, Christy, own a property together and we own it as joint tenants with each other, it means that we together we own the whole property. You own 100% of it,
Just
and
as much
I
as
own 100% of it. If I should die, Christy, you, the survivor,
the
then
sole
own
owner.
100% of it on your own. You are the sole
And
owner.
likewise.
Likewise, if you die, I am the survivor and I own 100%. If three of us own this property as joint tenants and I die, my share goes equally
It automatically transfers
to the two
the
survivors.
Okay.
And they now own it equally, 100% each. It means, therefore, that neither of us or neither of them can put that property in their will because the survivor is the person who is going to get that property. So sometimes
I
husbands
think
and
your
wives.
best bet there is to what? To split
Well,
it?
I have, there's a way that it can be written in your will
Okay.
that allows you to still put it in your will. It
Okay.
depends on the wording. There's another bet there that you can do. You can have the joint tenancy severed.
Yes.
You will need an attorney to do that. You can have the joint tenancy severed, and it can be made tenancy in common, meaning that each party owns a specific share of the property. It could be that each party owns half in common with the other. Or each party, if there are multiple parties, each party owns 1/3, 1/3, 1/3, or 1/5, 1/5. Or you may own half, and the other two people may own 1/4, 1/4. Whatever their agreement is will be followed, but it will be tenancy in common. And I will give you an example of what one client explained to me. Her mother had bought property for her 5 children that she intended to leave for them after she died. She had 99% of the cash that she wanted to purchase the property for. She relied on her brother to come up with the remaining 1% because she was short of that 1%.
Yeah.
He came up with it, and I don't know what the mother explained to the attorney, or what the attorney explained to the mother, but the attorney prepared the deed, and he prepared it, making the brother and sister, joint tenants. Now, the sister, having forked out 99% of the,
He
of
just
the
came
money,
up with 1%.
she believed that fairly
She deserved.
he should get some little part because he helped. But the deed was prepared
And joint
in,
tenancy.
as joint tenants. So when the mother died, the children all believed, based on what she had told them,
Yeah.
that they were now going to become the new owners of the property. Except the uncle explained to them that no,
It's not like
it's
that.
not like that. It's all mine. Because the deed was prepared in such a way where he was a joint tenant with his sister, their mother. So he walked away with it all. And none of them understood how that worked.
Yeah.
So only when I was preparing a will for one of the children, and I explained the concept of joint tenancy, did she understand how come they were not able to inherit mommy's property.
And therein lies the importance of knowing
Yes.
and not just sitting and waiting for information to come to you, but going out there and seeking your legal advice.
Yes, get your advice.
Property, estate is something very tricky.
Yes.
You have to know what you're doing.
Or you have to be informed. One of the things that I always say at the beginning of every lecture is that when I leave the room or when we part ways, my objective is for you to know some of what I know.
Yeah.
Because you can't possibly explain to me every little detail of your family circumstance.
No.
But you know it in every minute detail. Your husband may know it. Your mother, father, uncle, they may all know it. And they may each have different versions or perspectives of the same information. If, however, you are armed with knowledge, you can strategize. And that way, the only time you go to your attorney or me to ask me to prepare a will for you is when you've already strategized and you're coming to me with your instructions.
Yeah. Let's talk a bit about property and transferring of property.
Yes.
What are some of the do's?
If you're transferring property, most likely you are either purchasing or you are, one of the parties in a deed of gift. If you're purchasing, one of the important things that you should know is to get legal advice.
Yeah.
Because very often we decide to be cheap.
That is true.
We decide to be cheap and not get legal advice.
Yeah.
But we may walk into the room and sit at the negotiating table and realize, wait a minute, there's an attorney present. And
I could talk to him as
I
well.
can talk to him, he's here.
But you fail to realize.
He's not representing you. You never hired the guy.
Yeah.
You never hired the woman. So she's representing the other party at the table. So you may be presented with a sale agreement. And you look it through and you realize, wait a minute, there's legal stuff written on this here. It sounds like a qualified attorney prepared this document. Yeah, it says the amount that I'm willing to pay. It says the correct address and everything. And you sign.
Yeah.
And you pay your money.
And again, we probably didn't even read what we're signing for.
We probably didn't read what we were signing. And sometimes even if we do read it, we didn't quite understand all of the legal expressions that are on that document. So I lecture to many people. I lecture to soldiers, I lecture to firemen, nurses, doctors, and I explain to them.
And now you're here lecturing
And
to
now
public
to
servants,
public servants.
as well.
And I'm happy to be here.
Yes,
And
Friday.
Every Friday, I'm here at the PSA lecturing
Yes.
to public servants,
Listen, every
members
Friday.
and staff of the
Yeah.
PSA. And persons are trained in their profession. I won't tell a doctor, or at least I'll try not to tell a doctor, how to go about doing a surgery. I won't tell a fireman how to out a fire, and I won't tell a soldier how to defend my country.
Yeah.
But at the same time, he should try to rely on a professional who is an expert in law
Yeah.
to guide him and advise him on how to go about entering a legal transaction. So don't be cheap. Pay a lawyer. Let him represent you.
Yeah.
Don't be cheap. Sit in the lecture, learn a few things that allow you to strategize
Yeah.
on your own.
I don't want to give away too much from your lecture. You know, I want the public servants to come in and, of course,
Yes.
learn, like you rightly said, take away something,
Yes.
learn from you. Because I'm sure many people are out there, you know, you have your property, you have your deed, but the deed isn't enough. You know, it's there, but you need something to take you, to carry through after your death.
Well, yes, that's right. While the deed is there, it's not the be-all
No, it's
and
not.
end-all.
Because after you
need-
die, your property is still there.
It's still there. We're going to leave it behind.
Yeah.
That's the system God put in place, and we cannot change it.
No.
We are, each of us, going to die, and we simply can't take it with us. So the best plan is to make arrangements while we are still alive.
Yeah.
Now, here's a major challenge that the younger people are having. By the time they listen to the lecture, and they say, oh my gosh, I didn't realize that the situation was what it was. I need to go home
Yeah.
and explain to my mother and explain to my father or granny or granddad just how bad it would be if they die without leaving a will or without doing any kind of estate planning. So they go home and they explain what they heard today in a lecture. And mommy and daddy might say, listen, I have a plan. I already said the piece in the front
word of mouth
is for you, and the piece in the back is for you, and it's just words. Or sometimes they may decide that they're going to write a note.
Oh.
A lot of people do that.
Okay.
They leave a note saying,
I thought it was, I'm word of mouth. I tell you today that is yours, and tomorrow I tell you, no, that's your sister's. I didn't tell you that's yours.
That changes a lot too, right? But wills, fortunately,
Yeah.
even a will can change every single day. But a note is just not going to cut it either. A note, it does not help. So even the fact is that note will not stand up in court. Now the trouble people are having, or the challenge younger people are having, or anybody who listens to the lectures, when they go home, their parents are not as excited, and they remain ignorant because they did not sit in the lecture. So the words of our parents are this. Usually, it's this: "You're trying to kill me, right?
Or you're trying to thief my property.
You're trying to thief my property. I already said that is yours and your sister own, and or they'll share it and stuff like that." But those things just don't cut the mustard.
Do the proper thing.
It has to be done properly. The challenge is trying to know, now that you have been educated, to go home and educate your parents or to educate the owner of the property. They may be holding on to it so dearly because that's their livelihood. So what did I do? I called someone from TOP, the Trinidad and Tobago Association of Retired Persons. I called someone from there because they have their groups. And I said to them, listen, there's a problem here. There's a disconnect between the younger generation and the older generation with respect to leaving property for them or doing any kind of estate planning. And one of the members of TOP explained to me, listen, the trouble we are having is that there are young people who are taking advantage of us. Some elderly people are being abused, and they're taken to the bank every month. They take the pension, the person's pension, and they don't take care of them with their own pension money. And the next time they see that young person is the next month end, when it's time to collect the next pension check. So there is a problem in our society in that regard. So a lot of the elderly are holding on to their property for dear life because that's the only leverage they might have against an abusive nephew or an abusive grandson. So society has its problems.
How do you think we can fix that problem though? I don't want to say barrier, but it's a gap between the young people, old people, generating information, being aware first of all, and the older folks not feeling like, okay, this is just another case. I read about it. My grandmother told me that somebody outsmarted them, and how do we now get that through the older folks' minds that hey, we're not going to steal your property. We're just ensuring that you do the correct thing.
Education. Education is the key. If the legal fraternity can get to reach everybody and educate them, it's not as though you're not going to continue making money by keeping the information to yourself. In fact, it's quite the opposite. The more that the legal fraternity shares the information with the public, because a lot of people don't go and do their own research until they find themselves in a problem.
Because we're at the age of technology
where it's right there.
It's at your fingertips.
So a lot of us, young people, middle-aged people, old people, we do not go and research anything until it becomes a problem. Right? But education is the key. I adore what PSA is doing. PSA is encouraging all staff and all membership to come to these lectures and based on the feedback that we are getting so far, people are now able to go home to their husbands, their wives, their children, their parents, and strategize as to what they're doing. So we are now getting calls from these persons after they're finished deliberating with their family. Listen, here's what I'm thinking of doing, which means that it's a success because now people have gone home, they've strategized, and now they're coming back to us saying, this is what we have decided to do.
Yeah. Okay, it's just about 9:01. So we're going to toss the news right now, and when we come back, we'll continue our discussion here on PSA TV. Stay with us. And welcome back to PSA TV. This is the Wake Up Call here with me, Christy Kalising, and on set I've got Mr. Michael Lopez, the paralegal. And we've been chatting this morning about the importance of succession planning, the importance of having a will, and as you all know, this and every Friday, Mr. Lopez is in our building from 12, is it?
From 10 to 12.
10 to 12. So feel free to come on down. Get informed. As we rightly established, education is the only way going forward.
Yeah. It's the only way, Christy, that we are going to resolve the problem with respect to succession planning.
Yeah.
I think that what we do here at PSA with these lectures is family oriented, and it's a very good human resource program that the PSA has implemented both for members of staff as well as for its very large membership. So please make sure to take the time out from your schedule. Make sure to come down here on at least one Friday between the hours of 10 and 12 and learn to strategize.
I guarantee you will learn, trust me. I went in with a very reluctant mind because I think I was hosting that day. And I said to myself, oh my God, I have to go and listen to somebody speak
wills, oh my God.
And I'm like, traditionally we were taught that wills are very, it's just a piece of paper.
And it's a morbid subject.
And it's a very, to be quite honest, and I'm sure a lot of people would agree with me, it's a very lengthy kind of boring subject, but you made it very interesting.
Thank you for telling me
And I think that you always relate it to something that we can relate to.
Yes.
And it's not very, my attention span isn't that, I'm not Dory, but.
Yet you sat there for 2 hours.
I sat there.
And you asked questions.
I did,
and you stayed a little longer afterwards. Yes, that's good.
And I was able to tell, my peers here, like, listen, go to it. Trust me, if I can go to it, you can go to it. Because I am not the most attentive person, especially when I'm finished hosting. I'm just like, okay, that's it for today. But, it's really, really informative. You might think that you know everything about your property, about what you need to know, but trust me, you leave a better informed person.
In fact, Christy, there is that one person who came to the lecture after you did.
Yeah.
And she said, listen, why am I here? I know this already. I'm already doing letters of administration. I don't trust wills. And you know what? You have to pay this amount of money to a lawyer if they're doing this for you and if they're doing that for you. And by the time, I shook my head and I listened to her. But by the time the lecture was over, she was the last person there, drawing diagrams on a blackboard and showing me, okay, so what if I do this? And I combine that with it. Will that work? And so she became very interactive. She stayed for about 2.5 hours. I was ready to go, but she really had a lot of questions because she was now able to put the information that she received with the situation that she was going through, correct any misunderstandings, phobias, or myths that were prevailing in her mind.
And these things come with a lot of myths.
Yes. So I'm happy to help, and I'm glad that PSA is pursuing this initiative. I don't think
they could have chosen a better teacher or lecturer for us.
Thank you very much.
So, it's not just for our benefits, but it's something that you can now go home, like you rightly said, tell your other half, your children, your parents, I know parents, that's kind of tricky.
Parents is the challenge.
That's kind of tricky. But luckily, my mom is very open and understanding.
Great.
So I was able to convey what I learned in a very good manner. It's just, not everybody would be like that.
Yes.
So, your closing comments before you wrap things up for today?
My closing comments are that please get some advice about succession planning, about wills, about estate planning. If you do not have the good fortune to sit in one of our lectures, then get on to your attorney and ask them as many questions as you can about succession planning as it relates to you. There are little unknown tricks to the trade. There are situations that you might find yourself in that you didn't know about, like your credit union, your pension plan, your investments, your unit trust, etc. Even your life insurance policy comes into play, especially with regard to who you're leaving as your beneficiary. Those issues are very important. Ask your professional, your legal professional about it. Get in touch with the paralegal and get the job done.
And come on down on Friday at 10 a.m.
And come on
Last
down on Friday
but
at
not
10 a.m.
least. So, Mr. Lopez, I want to thank you so much for coming on this morning.
Thank you.
Again, very informative. I myself have learned a lot. So now I'm better able to talk about these things, with a little more confidence.
Yes.
So thank you so much for coming on this morning. And
You're
I'm
welcome.
sure that our viewing audience will appreciate all that you've imparted on them this morning. So again, if you want to, it's not a matter of if you want to, but I think you should. Yeah. You should come on down. It's free to the public servants, of course. Come on down to our headquarters here on Abercrombie Street and get informed.
Thank you.
Thank you so much. So we're going to toss a really short break, and when we come back, we'll continue our programming here on PSA TV. Stay with us.